So I'm going to move it down a little bit. Perfect.
All right. Hello, everyone. Welcome to our little live Hot Topic series. Care Partners has had to suspend all of our in-person events due to the coronavirus and everything that's going on right now. But we are still absolutely dedicated to supporting and encouraging our family caregivers. So we'll be bringing you lots of different educational and resource material. So be sure to follow us on Facebook, check our website, and today, I'm so excited to introduce you to Ruth-Ann Toups from Toups Law Firm. She's going to be talking about why powers of attorneys are essential for caregivers. So hello, good morning, Ruth-Ann.
Good morning.
We're going to go ahead and get right into this hot topic today. Here we go.
Awesome. Well, I was so excited when Darian asked me to present, and we were brainstorming topics, and I suggested powers of attorney. And I did that because I find that they're one of the most overlooked parts of an estate plan. So when I talk to families about estate planning and about elder law, one of the first things that I'm talking to them about is powers of attorney. I'm asking, does anyone have a power of attorney? Have you executed a power of attorney? And I often see that this is an overlooked part of the estate plan. So I really wanted to dig into what powers of attorney are. There's two, and we're going to start with that, why we need them, how they're used, and some of the really common myths about them, because I think they're pretty misunderstood in a lot of ways. So we'll start with the medical power of attorney. So here in Texas, we have two different powers of attorney, and the one that you're probably most familiar with is the medical power of attorney. And that's what allows someone to make a medical decision on your behalf. You're not able to do that for yourself. These are done a lot of times in hospital settings. I have a lot of clients that come to me that maybe they had a procedure or they were in the hospital unexpectedly, and maybe a social worker at the hospital helped them execute a medical power of attorney. And they think, awesome, I have one in place. I don't need to worry about powers of attorney again. That's not true. For one, it's only a medical power of attorney, and we're going to talk about how it's good, but we really need the durable as well. But the other aspect is that with a medical power of attorney done in a hospital, there's a lot of things that I see as issues. The first thing that I run into quite a bit is these generally don't have a HIPAA release inside of them. And that's that law, HIPAA, that allows someone to share and receive private medical information on your behalf. So if your power of attorney has the ability to make a decision for you, but they don't have the ability to get the information they need, or maybe set appointments or communicate with doctors on your behalf, it really cripples their ability to carry out duties on your behalf as medical power of attorney. Now, a lot of people have a medical power of attorney, and then at each hospital or with each doctor, they separately sign a HIPAA release, and that could work, but it's not the ideal scenario. The ideal scenario is that we have a HIPAA release inside of our medical power of attorney. So that's one issue that I see a lot. And the other issue that I see commonly with hospital executed medical powers of attorney is we have no backups. And that's an important theme. I mean, that could be an entire presentation on its own, but backups are incredibly important. We want to make sure that we have our first choice agent, we have a backup to them, and ideally even a backup to them as well, especially when we're talking about the medical power of attorney. If it is the middle of the night and they cannot get a hold of your first choice, they can't get a hold of your second choice, we really want to have kind of a several different options on there of people to call. And we want to make sure that we have good contact information on there. I see a lot of powers of attorney that don't have accurate contact information. If someone has this document, you're in the hospital, and they don't even know how to reach the decision makers in your life, and that can be very difficult. So those are some issues that I see a lot. A lot of people that come in with a medical power of attorney done in a hospital, they can work, but sometimes we need to expand on them as well. So in addition to the medical power of attorney, we also want a statutory durable power of attorney. And that's really something that I like to refer to as a financial and legal power of attorney, but it does so much more than that. This is a power of attorney that allows someone to act on your behalf for financial and legal matters. And that can mean a lot of different things. That could mean real estate transactions. It could mean talking to the IRS or to Social Security. It could mean dealing with an estate transaction. I have several probate cases right now where there's beneficiaries that need someone to act on their behalf. There's all kinds of different ways that we may need someone to act on our behalf. And I think when we think about powers of attorney, we often think that this person's going to become the sole decision maker in our life. And that's not really true. Our power of attorney is empowered to act in the way that we want them to on our behalf. And so the power of attorney can't just say, well, I'm in charge now, so you're not going to bank here, and we're going to start paying this bill and not paying that bill, and so on. As long as you have capacity to call the shots, you are calling the shots. And if your power of attorney diverges from what you want, you can fire them as your power of attorney. You can revoke that power of attorney. And using this statutory power of attorney that we have actually allows you to sue them. If for some reason they did something, let's say they stole money from you, which does occasionally happen, we could sue them using a statutory power of attorney. Whereas a lot of the other powers of attorney out there that don't follow the statutory requirements, we may not have those same remedies under them. So it's a little bit about, I hear a lot of people come in and say, well, if I sign a power of attorney, my son or daughter is going to be able to make all my decisions. They'll be able to do everything for me. They can act on your behalf, but they cannot take over or be in control. The reason that this statutory power of attorney is so important is imagine, and I don't think it's hard to do in this current time, if you were not able to carry out your daily activities, you weren't able to make your bank run, or you weren't able to go and sign the documents that you needed to sign, or you couldn't make a phone call, you couldn't call the cable company or the light company. These are all things that in order for someone to do those on your behalf, they need that legal authority to do it. So I've had lots of clients come in and they're helping mom, and mom reaches a point where she's struggling to do those things on her own, and daughter tries to step in and finds that her hands are tied. She's experiencing a lot of red tape. And I've had this come up in all kinds of ways, from as small as dealing with the light bill to as large as trying to deal with a real estate transaction, or trying to access a personal injury settlement. There's all kinds of different ways that this comes up. Without someone named to act on your behalf, you're just not able to carry on that business. So what happens then? Well, if we're capable of signing a power of attorney, we can certainly execute one when the need arises. But what I often see is when this need really becomes urgent, we no longer have what we call capacity. We don't have the ability to execute that power of attorney with enough knowledge to really understand what we're doing. And so in those situations, what we have to do is we have to seek a guardianship for that person. And that's a court proceeding. And that's where we actually go to court and ask that someone be named that person's guardian. And that's something we want to avoid for a lot of reasons. Number one, no one likes going to court. It's not a fun process. It is expensive. It's time consuming. It can take several months and cost quite a bit of money to get this guardianship. And I've come across a lot of cases where there's just not the funds to do it. We need to be able to move forward, but we also can't really expend the funds to get the guardianship, and we end up almost stuck in a lot of ways. So one of my key pieces of advice, anytime someone comes in, and really whether they're 18 or whether they're 88, whether we're talking about estate planning or whether we're talking about elder law, but most especially when we're talking about elder law, I say you need these two powers of attorney. These are two things that we need to get in place so that someone can act on your behalf if you're not able to. And not being able to can mean a lot of different things. Not being able to could mean even that you're traveling or that you're out of town. I have a lot of clients who have a spouse that travels often for work. We use powers of attorney all the time in those situations because your spouse just may not be here to execute things on their own behalf for that time period. So powers of attorney are really something that we want to look to put in place if we don't already have them. We want to make sure that we're reviewing them frequently. So this is a question that I get a lot, is how often should I review my documents? And really, wills and trusts I find maybe a little bit more durable. They may last a little bit longer. But when it comes to powers of attorney, we want to be looking at these pretty regularly. We want to be asking ourselves, have there been changes in the law? Our statutory powers of attorney have changed significantly just in the last several years. We've had two major changes to them, and those changes have made them longer and more expansive, and they've allowed us to do more things. And so when it comes to a statutory power of attorney, the power of attorney lists exactly what that person can and cannot do. And we really generally, when we're talking in elder law terms, we want that power of attorney to be more specific. We want it to say all these things that could come up. And so I see a lot of older powers of attorney that are very general and very broad, and they're difficult to use. They're difficult to make them effective because we go to use them and then a particular institution says, no, it doesn't say that we can specifically do that. So we want to look at what's in there. Is the law changed? Can we redraft them to make them better suited for our current times? And we also want to look at who are the people named in there. Maybe we had someone, maybe our neighbor was helping a lot before and we had them as a backup. Maybe they moved now and we have a new neighbor, or maybe we had our daughter-in-law in there and maybe she's since left the family and we need to make changes. So powers of attorney are something that we want to be looking at usually at least every 2 years or so. And that doesn't mean we have to always update them, but something that we want to be really keeping a close eye on. So when we're thinking about our estate plans, when we're thinking about what we need as a caregiver, we always want to start with powers of attorney. And Darian, I don't know if we have questions from anyone.
Let me think up. Oh, it looks like we don't have any questions right now, but I would like to ask, what would you say is some of the biggest takeaways when it comes to powers of attorneys?
Sure. I think the biggest takeaway, obviously, is that we definitely need two. So if we just have one, it's a good idea to get the other one put in place. We also want to have an attorney review them. It's really important to do that. The medical power of attorney, less so, more so with the durable power of attorney. I see a lot of them that maybe were drafted well, but they weren't executed correctly. So I see a lot of them where we didn't initial in the right places, maybe we didn't have it notarized properly, and they're actually not even effective documents.
Wow. So it's very important then to get it reviewed.
Absolutely.
And so I guess this is the last thing. Are there any risks involved in giving someone a power of attorney?
That's a great question. So there are some risks involved in powers of attorney. And the risk is obviously that that person would abuse their authority. I hear that a lot. I hear that as a really big concern from people that are in my office. And it is a concern. It's something we want to be aware of. Something we touched on earlier was that under that statutory power of attorney, you do have the ability to pursue remedies. There's ways that we can go after them if they did something like, I had a case recently where the house was sold out from underneath the agent, power of attorney, sold the house from the person that gave it. And we were able to undo that. There's ways that we can do that using that durable power of attorney. I will say, though, that is incredibly rare. More often than not, the families that we're talking to and dealing with need these powers of attorney in order to avoid that court-ordered guardianship. So like with a lot of things, especially in the practice of law, we kind of have to balance the risk versus the reward. Of course, there's a risk involved in allowing someone else to transact business on your behalf, but the reward is that we're able to keep the government, the state, out of having to monitor those transactions on our behalf. So I think the best thing that you can do is make sure that the people that you are naming on those powers of attorney are people that you trust. And you don't just trust them now when you're able to kind of oversee what they're doing, but you feel like you would trust them even if you weren't able to oversee that. And that's a great reason to rethink your powers of attorney frequently too. Just check back in with yourself and make sure I still feel comfortable having this person named.
That's great advice. And it looks like we do have a question now. What is the general cost for both types of powers of attorney?
Sure. It can range. Every office is different. I will tell you in my office, we do everything on a flat fee basis. There's a lot of kind of ethical rules about talking about prices and things like that. But you can expect to spend several hundred dollars to get the powers of attorney done by an attorney. There are forms online, and they work okay. Again, the key is making sure that they're executed properly. I usually say that if we are concerned about an aging loved one, if you are a caregiver, it's well worth the investment to sit down with an estate planning attorney or an elder law attorney and get the powers of attorney drawn up. I put what I call kind of an elder law flavor on the powers of attorney, and we do that to make sure that we're talking about benefits in the future, maybe VA benefits or Medicaid benefits. We want to make sure that person is able to do whatever they need to do to maybe access those benefits.
Very good advice. Well, thank you again so much for being here. That was all of our questions. I'm sure we'll be doing more like this in the future. So everyone comment different topics you'd like. And if you still have questions for Ruth-Ann, we'll be answering questions throughout the day. So thank you again, everyone. For more information on all of our updated programs and everything that we're doing during this time, be sure to visit us at our website, on our different social medias. We'll be updating and bringing more content. Later this afternoon, we'll be doing a musical exercise for you guys to follow along to. We'll see you later today. Thanks again.